Good afternoon. My name is as the Connecticut Law Review's Volume 56 Symposium editors. Julia and I are delighted to welcome you to Interrogating Haaland versus Brackeen, Family Regulation, Constitutional Power, and Tribal Resilience. To start the Connecticut Law Review Symposium, we want to recognize and thank the indigenous peoples who are native to this area and the enslaved people whose labor enriched this land by reciting a land and labor acknowledgement. I'm speaking to you from the territory of dispossessed Mohegan, Nipmuc, Niantic, Paugussett, Pequot, Quinnipiac, Schaghticoke, Tungssis, Wangunk, and other Algonquin peoples who have cultivated this land and waters for centuries.
Was also enriched by the labor of enslaved people, both the southern cotton production that fueled northern manufacturing, finance, and trade, and the black and indigenous people enslaved in Connecticut, which did not fully abolish slavery until 1848. Thank you for your attention today and your willingness to join us in exploring the impact of the Brackeen decision and the importance of the Indian Child Welfare Act. We would now like to invite Dean Ebony Nelson to formally welcome you to the symposium on behalf of the Yukon Law community.
Good afternoon, everyone. On behalf of the University of Connecticut School of Law faculty, staff, students, and alumni, it is my honor and pleasure to welcome you to the Connecticut Law Review Symposium exploring the important topic of interrogating Haaland versus Brackeen, family regulation, constitutional power, and tribal resilience. This case arises from the consolidation of 3 separate child custody proceedings governed by the Indian Child Welfare Act, also known as ICWA, a federal statute that seeks, and I quote, to protect the best interest of Indian children and to promote the stability and security of Indian tribes and families. This is not the first and likely will not be the last case challenging ICWA and the protections it offers. Preservation of tribal sovereignty and the constitutionality of ICWA will remain a concern as future cases arise. Given the importance of family, culture, and community for all children, particularly Indian children, I applaud the Connecticut Law Review for selecting this timely and significant topic for its symposium. And I thank all of you for taking the time to join us for what promises to be an informative and engaging discussion. The Law Review has assembled a stellar group of leading scholars, attorneys, and tribal leaders to explore the issues surrounding this important decision. And I thank and welcome all of them for their participation. I would also like to thank our symposium editors, Casey Corvino and Julia Vassallo, who will moderate today's panels, Connecticut Law Review Editor-in-Chief, Gretchen Yelmini, and all members of the Law Review for their hard work in organizing today's symposium. I also thank their faculty advisor, Professor Leslie Levin, and symposium advisor, Professor Bethany Berger, for providing excellent guidance to the journal members. Last but definitely not least, I thank our events, communications, and information technology services departments for their assistance in organizing, publicizing, and facilitating today's program. At this time, I welcome Connecticut Law Review Editor-in-Chief, Gretchen Yelmini, to provide remarks. Gretchen?
Good afternoon. As Dean Nelson mentioned, my name is Gretchen Yelmini, and I am the Editor-in-Chief of Volume 56 of the Connecticut Law Review. As our symposium editors, Casey Corvino and Julia Vassallo eloquently stated, we are here today learning on the land of indigenous peoples, and we honor and respect the enduring relationship that exists between these peoples and this land. It is my great privilege to welcome the impressive slate of tribal leaders, scholars, and practitioners who are with us today. They are generously sharing their time and expertise with us all as we interrogate the Brackeen decision and what it says for the future of the Indian Child Welfare Act and the state of federal Indian law. My first exposure to Haaland versus Brackeen was in the fall of 2022. I was in Professor Berger's American Indian Law class, and as she often does, she assigned us an oral argument. It was to argue one of the positions in Brackeen. At the time, the case had not been up for argument before the Supreme Court. And in reading and dissecting the briefs, there was a great deal of anxiety about what the court might decide amongst my peers. The collective uncertainty evolved into cautious optimism after Brackeen was argued before the Supreme Court. My classmates and I listened to the oral argument, eagerly texting back and forth with our thoughts on the lines of questioning and speculation on how the case might turn out. We were hopeful that despite the makeup of the present court, ICWA would withstand the attacks levied against it by the Brackeen plaintiffs. Perhaps due to the shared sense of hope, a few weeks later, Professor Berger came to me with an idea for a symposium. And it is because of her guidance and support and the genuine respect that she and the rest of our panelists have for Native families and the issues of tribal sovereignty that we are here today. It is important to note that ICWA is not the end of ICWA's story, nor have attacks on Native sovereignty and efforts to undermine this statute ceased because of the court's 7-2 decision. But it is a moment to celebrate. It is also a moment to pause and remind ourselves that, just as Congress recognized in 1978 when it passed ICWA, there is no resource that is more vital to the continued existence of and integrity of Indian tribes than their children. On behalf of the Law Review, I want to sincerely thank our panelists for sharing their knowledge with us today. I also want to recognize and thank our attendees for their attention and willingness to learn more about these issues. Finally, I want to personally extend my gratitude to UConn Law Events Manager Deb King, Symposium editors Julia Vasallo and Casey Corvino, and our incomparable Symposium advisor, Professor Bethany Berger, for putting together an incredible program. Today's symposium will feature 2 panels. In the first panel, our speakers will focus on the Brackeen case. Our speakers will provide attendees with an overview of the case and discuss the path that the litigation took up to and through argument before the Supreme Court. Additionally, the first panel will discuss the impact of ICWA and U.S. tribal relations with a focus on the Aquinnah Wampanoag tribe. The second panel will provide context to the constitutional and broader political struggles that came together in Brackeen. This context will include how Brackeen relates to broader attacks on families of color and the equal protection and race-based challenges that Brackeen left unaddressed. Our panelists will also discuss the battles over original intent and federalism featured in the Brackeen arguments and opinions. Thank you again for your time and attention today. We hope to foster an active and inclusive discussion. We encourage all of you to post questions in the chat feature, which will be shared with our panelists. We will now take a 2-minute break before beginning panel 1, which will be moderated by Law Review Symposium editor Casey Corvino.
Hello again. On this first panel, we have attorneys who have been involved in the case from the very beginning, the attorney that argued the case before the Supreme Court, Chairwoman Cheryl Andrew Maltese from the Wampanoag tribe of Gay-Hetaquina, who can not only speak to how this has affected her people, but who has also created the regulations implementing ICWA. I invite you to read more about today's speakers in our virtual programs. But first, I would like to welcome Professor Bethany Berger, Wallace Stevens Chair and Professor at UConn Law. Thank you.
Thank you so much for being here, and thank you to Gretchen and Casey and Julia and all the law review editors for all your fabulous work, and thank you to these amazing panelists. I am going to incredibly quickly give a rundown of Brackeen, just to give more time for our panelists who know much more about it than I do to get into the details of it. So the Indian Child Welfare Act was created in 1978 to address radically disproportionate removal of Indian children from their families and communities. It applies to foster care, adoption, pre-adoption, and termination of parental rights cases that involve an Indian child. That is one who is either a member of an Indian tribe or who is eligible for membership in Indian tribe and is the biological child of a member of a federally recognized Indian tribe. It affirms exclusive tribal jurisdiction when the kid's domiciled on the reservation, and encourages state jurisdiction when the child is not, but many cases wind up in state court. And that's the kind of case that Brackeen involved. If the case is heard in state court, among other things, one must show that active efforts have been provided to prevent the involuntary breakup of a family, must provide notice and a right to intervene to tribes, and in adoptive placements, which is what Brackeen concerned, you have to show absent good cause to the contrary, that you prefer placements with, in this order, a member of the child's extended family, other members of the Indian child's tribe, or, and this is part of the focus of Haaland v. Brackeen, and now that tribal interests have won, I like to call it Haaland v. Brackeen to acknowledge Deb Haaland, Secretary of the Interior, first Indigenous Secretary of the Interior. And as Professor Fort's going to discuss, there were many challenges filed around the same time to the Indian Child Welfare Act. The one that made it through was this case filed by 3 sets of foster parents that wanted to adopt Indian children in their care, and Texas, Louisiana, and Indiana against the United States. 3 states, three tribes intervened in the case. The district court judge, who Professor Fort might tell you about, holds ICWA unconstitutional on multiple grounds. A panel of the Fifth Circuit reverses, but then it went en banc before the Fifth Circuit, and in a 300-page plus opinion, which I'm so glad I never have to read again, the court rejected many of the district court's findings, accepted a few of them, and because it reached no majority opinion on others, affirmed them without opinion, and all parties petitioned for certiorari, which the court grants. So there were 3 main buckets of challenges in the Supreme Court. First, as to constitutional power, that the Constitution didn't authorize Congress to enact ICWA. Second, a bucket of federalism type charges, that ICWA unconstitutionally commandeers states or otherwise unconstitutionally undermines state sovereignty. And finally, individual rights charges, that ICWA's placement preferences in particular violated equal protection and the non-delegation doctrine. And we'll talk after arguments. I thought it might be 5-4 in favor of the tribe, or it might be 4-5 against the tribes. But in fact, it was 7-2 in favor of the tribal interests. First, as to that first bucket of challenges, the Supreme Court said, oh, yes, Congress can do this. Second, as to the federalism charges, the court said, besides the record-keeping requirements, ICWA only requires states to provide the same kind of rights in ICWA cases that individual parties, private parties have to provide. And finally, as to equal protection challenges, they didn't decide them. They held that the parents didn't have standing because they were just asking to enjoin the federal government, and ICWA cases happen in state court. And Texas states don't have equal protection rights. So with that, I will turn it over to Kate Fort, the Director of Clinics and Director of Indian Law Clinic at Michigan State University Law School, who knows more about ICWA than anybody I can think of who was involved in representing the tribal parties in this case from the very beginning. So thank you very much, and I'll turn it over to Kate Fort.
Well, thank you very much, Bethany, and thank you for having me. And I have to agree and thank the students. They've done a really lovely job of organizing this and keeping us all on task and together. I also want to say it's really nice to see Ian, who I haven't actually seen in a long time. This kind of practice is very strange, where I work with outside counsel very intensely for a while, and then, you win a case and you go on to your next stuff. So it's really lovely to see him, and really honored to be on the panel with the chairwoman as well. So thank you. Yeah, I've been asked to sort of talk about, like, how did we get here? How did we get to this case in front of the Supreme Court? And I was thinking about this morning, and I can talk, obviously could talk about this for a really long time. So this is a very high overview. But one of the things that I think is really important to know about the buckets that Professor Berger identified is those are not new arguments against ICWA. You can go into the legislative history and you can see Congress wrestling with these exact same questions. You can see the Department of Justice coming to Interior saying, we're not sure you actually, and to the Senate saying, do you really think you have this authority? And the Senate and the House saying, yeah, absolutely, no problem. There's no problem here. We have this authority, and writing reports about it and addressing all of the same issues regarding the power of Congress to legislate on behalf of Native people who live off reservation, the power to get involved in family law, which is primarily a state area, and the concern about applying ICWA to parents who are non-Indians, right? And what that looked like. And so that's been something that's been a part of ICWA since its passage in '78. These challenges, to me, over time, have come to feel like they come in waves. And so one of the big first ones, which actually I wasn't involved in, I was too young to be involved with the one at the time, started in the '80s, and it started primarily with adoption attorneys. It's often adoption attorneys. ICWA causes friction in adoptions purposely. It sort of slows things down. It forces certain consents from parents that are not required, that are otherwise governed by state law, and that may not be required. They now kind of require notice to the tribe, or at least a confirmation whether the child is a tribal member. And that friction often causes issues with the adoption attorneys and private adoption agencies that are looking to effectuate these private adoptions. And in the '80s, they actually went to Congress. So the first time that we had a big push on this was a congressional attempt where they went to Deb Price of Ohio and wanted to change ICWA. And there was all in the legislative history after ICWA, you can see all the drafts that they looked at to amend it. And actually, tribes got involved at that time. And I think most of us agree we would have taken those amendments, that it ended up being pretty favorable, especially on notice and private adoptions to tribes. And ultimately, that legislation didn't really go anywhere. And we were back to sort of the regular litigation. Something important to know about ICWA is that it doesn't have, it's not tied to funding, right? Which is one of our issues, which is why is it constitutional? So there's no way to enforce ICWA sort of outside of an appellate process, which I think is it's kind of ironic for me because my work is almost entirely representing tribes on appeals on ICWA cases, but that generally an appeal is not your best way to be dealing with a child protection case, right? It extends the life of the case, it delays permanency for the child, it causes questions, but ultimately the only way to ensure that ICWA is followed by trial court judges ultimately is going to be often through an appellate process. And so I find tribes to be really thoughtful about when they want to appeal, what they're going to appeal, and understand that what happens is going to affect all of Indian country and not just that tribe. But the thing about ICWA appeals, is that they're almost always, like 98% of the time, not brought by tribes. They're almost always brought by either parents, foster parents, or the state, mostly parents. And so ultimately the work is to ensure that tribal voices are heard in these appeals that sometimes may just include a parent and the state. And so that's essentially the work that I do and why I came to this case with the tribes that intervened. And I have to say this because I get called out on this a lot. So there were 4 tribes that intervened initially in October of 2017. They were Oneida Indian Nation, the Morongo Band of Mission Indians, Cherokee Nation, and the Quinault Indian Nation. And Navajo Nation always needs me to say, and if they're in the audience, I'm saying right now, they intervened for the purposes of a Rule 19 motion, and then they intervened for the purposes on appeal. So ultimately, there were 5 tribal nations that intervened as parties in the Brackeen case. 3 to 4 of those were my clients, depending on the time frame of the case. The case did start in 2017. I really love the student who said she didn't have to think about the case till fall of 22. And I'm like, man, that would have been sweet to have those 5 quiet years in my brain. But the case of Brackeen, I'm going to keep an eye on the time, really comes out of the most recent attack. It was 10 years almost to the day from the decision of adoptive couple versus baby girl to the Brackeen decision, or the Haaland versus Brackeen decision. Baby girl, that case, interestingly, comes up through the South Carolina courts. And the South Carolina courts actually find it's a private adoption again, ultimately find for the father all the way up. And only once the case goes to the Supreme Court do we find ourselves in a situation where we have the dad, we have the adoptive parents, prospective adoptive parents, and then the mom, the biological mom, participates in that. Cherokee Nation, even though they were intervened below, were unable, you can get a lot of different Supreme Court gossip on this, but they did not participate in oral arguments for various reasons, and the United States was involved in that case. And that case, I was thinking about it today, the outcome of that case was sort of the opposite of the outcome in Haaland versus Brackeen. So in baby girl, that involves the child, baby girl, and the loss in that case means that child is removed from her dad. She is taken from her dad, who she had been living with up until the time that case comes down. After 6 months of legal fighting on the ground, after the case is decided, she is transferred from her father to the prospective adoptive parents, where, as far as we know, she lives today. She's the same age as my youngest child, so she'd be 14 years old at this point. But that we lost that child, but the implications for ICWA were relatively minor. They were very cabined. Unless you're a putative father in Montana, you just don't deal with baby girl as much as we really thought would happen. It just isn't used as often. There's a few states that have adopted certain framing of it. It's not an ideal case, obviously, but it didn't have huge implications. Haaland versus Brackeen, of course, the other end is all 3 of the children involved, and these were foster care placements. And the question of whether these were foster care placements or adoptive placements was one that the plaintiffs purposely muddled, right? Like they purposely made it try to sound like these were voluntary adoptions versus foster care placements, which they were. So this was the first time the court is seeing an involuntary foster care placement. And in Haaland versus Brackeen, we win ICWA, the continuance of ICWA, but the children stay where they are. Nothing happened physically to the children that were involved in that case. But after baby girl is decided, the federal government under the Obama administration says, to tribes. They send a letter, this Dear Tribal Leader letter, which I've been trying to get my hands on for a very long time because I remember it, but I don't have a copy of it. I keep citing to it in my articles and telling the law review students, I swear it's out there. It exists. I promise. I've got an email from the assistant secretary's office saying it exists. They just can't find it. And they said, what do you want us to do? Like, how should the federal government help with ICWA? And tribal response ended up leading to the passage of federal regulations, though I still think the actual response was, we want enforcement, right? And one of the ways we thought about enforcement was, well, binding federal regulations that help explain certain areas of the law will be helpful. And so the regulations, we get the 2015 guidelines, we get 2016 regulations, we get another 2016 guidelines. And during this time from Baby Girl to Haaland versus Brackeen, we get a lot of federal filings. So we get a number, the three big cases that people often hear about are going to be NCFA, National Council for Adoption versus Jewel, which challenges the 2015 guidelines in the Fourth Circuit in Virginia. We get what is often called the Goldwater litigation, which begins in Arizona and is also going after both the constitutionality of ICWA and the regulations. And then in October of 2017, we get Haaland versus Brackeen. And I want to make sure I leave plenty of time for everyone else and questions. And so I'm going to kind of end that time on this observation, which is there's an intentional shift that happens from state court to federal court during this time. So the cases that make up Brackeen, those three cases, the Brackeens, the Librettis, and the Cliffords, are all cases that I knew about because people call me when cases go sideways in state court. No one, I always make this joke over and over. No one calls me when an ICWA case is going well, but a lot of people call me when an ICWA case is going poorly. And so when this federal lawsuit popped up, I'm like, oh, that's that case in Minnesota. Oh, I talked to that attorney in Nevada. Yep, I definitely knew about that Navajo case. And it's because they were all these state cases. And there was a decision at some point to take these and take them into federal court, where judges just generally don't deal in the area of child protection or child welfare, or depending on where you are and what you're studying, it's also more and more being called the family policing process that happens in our country when we're talking about children and families. And that shift to federal court, I think, is what made Brackeen really, and the 10 years prior, really difficult and new. And I think Ian is next, but one of the reasons why we needed to bring the experts that we did in federal court litigation to the table in order to make sure that the tribes that intervened were properly represented and were able to defend their interests in the case. So I am happy to answer questions when we get to that point. And thank you for having me again.
Thank you so much, the both of you, truly, for that really interesting description of the legal context and also just the nuances behind it. It was really fascinating to hear. I know next on our docket we have Ian Gershengorn, partner at Jenner & Block, former Deputy U.S. Solicitor General and Acting Solicitor General.
Great. I think so. Good. Welcome, everybody. It's great to be here. Thank you so much to Dean Nelson and Professor Berger, and as everybody's been saying, to Julia and Casey. Really appreciate it, and it is good indeed to see Kate. You'll hear about our interactions in a little bit. So I've been asked to talk a little bit about the presentation of the case to the Supreme Court. I got involved after the Fifth Circuit proceedings. And I wanted to just touch briefly on four main things today. One is the briefing and presentation to the court. Two, very briefly, how we thought about prepping for the court and what we were trying to accomplish. Three, a couple of short observations on the argument. And then fourth, if there's time, stepping back and talking about why this is such an interesting time to be doing interesting and challenging time to be doing these cases in the Supreme Court. So let me start with the presentation to the court. This is truly a situation in which it takes a village, and there are more people than I could identify to thank for the way this was presented to the court. But one thing I wanted to talk about a little bit was the Tribal Supreme Court Project, which has really been an extraordinary effort to help tribes in the Supreme Court. So it had its genesis more than 2 decades ago now, in the early 2000s, when the tribes were really doing very, very poorly in the court. They had lost like 20 out of 24 cases before principally the Rehnquist court. And it was the brainchild of folks at NARF and NCAI in conjunction with tribal practitioners to see if they could get together a group that would help tribes in the Supreme Court. And the idea was to marry up tribal experts in tribal law, with Supreme Court practitioners, so that the tribal folks would gain from the expertise of the Supreme Court practitioners, and the Supreme Court practitioners would learn tribal law, which of course is not something that most of us who practice in the Supreme Court had ever seen. There were not, when I was going through law school, there were not serious federal Indian law classes. And so the point was to sort of marry these two things together and help the tribes. And it did so in a couple of important ways. So one was to recognize that often the most important brief in a tribal case at the Supreme Court is the brief in opposition at the cert stage, which is to say, to keep it out of the court. And one of the briefs I'm most proud of, I was involved in the tribal Supreme Court from very early on. Riaz Kanji, who many of you may know, founding partner of Kanji and Katzen, had brought me in. He's a spectacular lawyer and was very influential at the start of this. But I did an op-cert for the Rosebud Sioux in a hot pursuit case, and we were deeply worried about it, and the court denied cert. And it's one of those victories of the tribal Supreme Court project that, sort of never makes anybody's radar, because the whole point is we kept it out of the court. And the tribal Supreme Court was very effective at that. But the second thing, which is really more relevant to the current, to Brackeen, was that the tribal Supreme Court project was undertook to make sure that the amicus presentation to the Supreme Court was as effective and powerful as it could be. And this turns out to be extraordinarily important in all cases, but particularly tribal cases. I mean, the justices don't come to tribal cases with a great knowledge about tribal law. And there's a real risk either that there'll be no amicus participation, or that it will be somewhat haphazard. And one of the most valuable things that the Tribal Supreme Court project does is coordinate the amicus efforts of tribes. And I know Professor Berger has been involved in a number of those over her distinguished career. And so that was definitely something that we benefited from in Brackeen. So in Brackeen, we really, NARF was leading this effort through the Tribal Supreme Court project, and we sort of conceived of the briefs in like 4 categories, I would say. First was to try to show what ICWA was doing in practice. And so there were briefs from child rights organizations, from the Casey Foundation, from the American Academy of Pediatrics, to show like ICWA is working and is making a difference in the world for children. And so we had a number of briefs focused on that. Second, we had a number of briefs focused on history, and Professor Oblofsky, who will be on the second panel, was deeply involved in this. But we had both history of the constitutional questions here, but then also history of the treatment of Indian children over the years. And because we really wanted to frame this case so that ICWA was seen as the latest iteration of how the federal government has treated Indian children for good and often for ill over the last 2 centuries. And so this was not a statute that was plucked out of the air, but is really continuation of federal involvement in the affairs of Indian children, and that mattered for constitutional reasons, which I'll get to shortly. Third, we had briefs from con law scholars. They were very focused along the issues that Professor Berger laid out at the start, to make sure we had an amicus brief tailored to each of the constitutional issues, to Article 1, commandeering, equal protection. And then we had briefs from entities. So a brief from all 497 tribes and 62 Indian organizations, a brief from states who supported ICWA, and then a brief from individuals like Robin Bradshaw, who was the adoptive parent of one of the children. And so the net effect of this was that we had a series of briefs tailored to issue by issue and sub-issue by sub-issue. And I think it strengthened the presentation to the court in a way that and made the presentation very, very effective. And we couldn't have done it without the Tribal Supreme Court project and all of the work that went in there. So then how do we prep for argument? So, going back to the point I made earlier that the justices are really not familiar with Indian law. And one of the jobs of Supreme Court advocate is to talk to generalist judges and generalist justices about the specifics of the case. And so, part of my job as advocate was to learn as much as I could about this case and figure out how it worked in the real world. Now, often, not so much in this case, but often that involves going out and seeing the area that's affected by the various cases. So when I did the Wagnon case, which was the first case I argued in the Supreme Court, I went out to the reservation. It was a tribal gas station case. I went out to the reservation. I walked around the gas station, walked to the casino, walked to the state road. So I had it in my head. When I did Murphy and McGirt, same thing. I went out to the Creek Reservation and took a tour and saw the hospitals that were being built. I talked to the tribal justices and saw the police stations and fire departments. And things like that were critical in being able to explain to the court how these things were going to work in the real world. So how did that translate here? Well, the way it translated here was, among other things, a series of, I'm sure from Kate's perspective, endless conversations with Kate Fort. It is such a blessing to have the nation's expert, leading expert on these issues on your team. And, not just to talk about the legal issues, which of course, she did contribute, but really to figure out at a nuts and bolts level how this worked in practice. Like, what was this doing to children, to families, to people who are trying to adopt? How did judges perceive it? And being able to do that not only gave me confidence as I was standing up there, but the justices were interested in it, right? You were able to talk. I was able to say, like, the way this works on the ground is the following. And I could do that with credibility because Kate had given me that credibility. And in fact, the highest compliment I got was after argument, Kate showed me a text she had gotten from a friend or family member, which said, "It was so weird, Kate. It was like listening to your voice come out of Ian's mouth." And I knew at that point that I had succeeded in my prep, that Kate had gotten me there. But so that was very much part of the argument. So the argument itself, I'll touch on just a little bit and talk about it from the perspective of trying to convey to the court in various places our legal position. So the first thing that's such a gift from the court under its new format is you get a minute at the start to state your case where they won't ask you questions. And that is extraordinarily valuable real estate. And so I used that time to try to outline what I saw as the core of the case. And I made basically 4 points. And you'll see they track sort of what Professor Berger set out at the start. A, since the founding, the health and safety of Indian children has been the province of the federal government and tribes, not the states, right? So this is something the federal government has the power to do. Second, there's no standing. A facial challenge in a case without standing is just about the worst way to consider the constitutionality of a major federal statute, right? Third, this is political, right? It applies only to tribes the federal government has recognized. It incorporates membership criteria established by tribes, sovereign tribes, and it relies on the political decisions of parents to remain tribal members. So this is political. It is not racial. And then finally, this is in the best interest of the children. And, that was obviously going to be a critical point. And at the start, we wanted to say, this protects child safety, facilitates access to critical remedial services to keep families intact, and it works to keep children with their families and communities. That's why ICWA is viewed as the gold standard. And, so we were able to use that first minute to say, like, this is what the case is about. As the argument progressed, and as you think about arguments, the one thing I wanted to touch on was a way in which the new format that the court has adopted really has facilitated this presentation. So the court has always had this kind of free-for-all where you can't, you sort of can't barely get a word in edgewise as an advocate. But at the end, then the court allows the justices to do individual questions, and that allows for a one-on-one with the advocate and the justice. One of the nice things about it, and played out importantly here, was it allows your allies to basically ask you a softball question and say, opine. or tell me why this is right. And I think that was really important actually in this case. So Justice Kagan in that period said to me, can you tell me why there's no standing here? And then it allowed me to speak for 2.5 minutes about why there is no standing. Obviously, Justice Kagan knows a lot of stuff that I don't know about court dynamics, and she obviously thought this was going to be a critical part of the case. And so she allowed me to put forth our arguments without being interrupted in a way that said, here's why the individuals don't have standing, here's why Texas doesn't have standing, and then that, of course, is how the court decided it. And Justice Gorsuch actually did the same thing. He said, can you tell me why there's not a commandeering problem? And it allowed me then to lay that out. And so this is a situation in which there's sort of a marriage of format and substance in a way that was really, really powerful here. And I think it helped to contribute to the extent oral argument ever contributes to the success. So let me just close. I mean, as Kate said, I could go on talk about this for the whole hour and change, but I'll just stop with a final sort of observation about arguing tribal cases at the court now and why it's such an interesting case and why it's such an interesting time. And I think it's such an interesting time because of two justices, Justice Gorsuch and Justice Thomas. And it is Justice Gorsuch, as you all are aware, has been such an extraordinary voice for tribal interests, both on substance and in the way he writes. Obviously, the McGirt case comes to mind, but he's writing constantly in a way that not only is putting forth a view of the law that he gets it, but he's doing so in using rhetoric and enforcement of promises and trail of tears and understanding tribal history in a way that really is extraordinary. And to have that voice in the room and to have that voice who speaks to the conservatives, talks about originalism and textualism and takes that seriously and still comes out the tribal way is extraordinary and extraordinarily important. At the same time, you have Justice Thomas, and Justice Thomas is a voice for rethinking in a fundamental way every aspect of Indian law. And just last term, in Brackeen, he wrote a concurrence advocating the end of plenary power. In Navajo Nation, he wrote a concurrence advocating the end of the trust relationship. And in the bankruptcy sovereign immunity case, he wrote a concurrence advocating the end of tribal sovereign immunity. And so, obviously not things I support, but you see why this is such an extraordinary time to argue in the court. We have in some ways these two polar opposites. One justice who speaks the tribal language and really gets it, and then another justice who's saying everything that has been pro-tribe in the law now should be rethought and reconsidered. And so in some ways for him, everything's up for grabs. And Brackeen had this back and forth. And so I will be sensitive to time and stop there, but it's such an interesting time to practice at the court, and obviously very grateful for all the work that went into getting this 7-2 decision to uphold this extraordinarily important statute.
Thank you. It does sound like a very interesting, audio problems. It does sound like a very interesting time to practice. I was going to thank you for your insider's perspective on the case and its prep. And also, speaking as a law student, the fascinating lesson in practice and what it kind of looks like at that level. So thank you for that. I know next we would like to invite to the imaginary podium, as it were, Chairwoman Cheryl Andrews Maltese of the Wampanoag tribe of Gayhedaquina. Thank you so much for joining us today.
Thank you. Winnikasakis, as you mentioned. My name is Cheryl Andrews Maltese, and I'm the chairwoman of the Wampanoag tribe of Gayhedaquina. And we're located on the island of Nope, now known as Martha's Vineyard, and we've been here for over 13,000 years. And I'd just like to say, katapatash, katapatash, katapatash. Thank you, thank you, thank you for not only having this forum here, but also for all of the work that you do in this space of federal Indian law. It's so critically important because most of the tribes simply do not have the resources, whether it's financial, human, or expertise, to be defending our rights underneath the provisions and the relationship outlined in the Constitution for our rights and our sovereignty, so that the work that you guys do as a team and as individuals are really making a difference in supporting us as sovereign nations, our rights, and the continuity of our community and our children, in this case, in our future. We've gone through 400 years of attempted genocide of our people. and the Christianity and the taking of our people, laws passed prohibiting us from being Indians, speaking, dressing, living, from our traditions, our spiritual practices, and everything that entails being who we are as Indigenous peoples have been taking a toll on us for centuries. However, the theft of our children is the most egregious and harmful genocide that you can possibly imagine. The pain that that causes, not only for the children, but the families, are felt for generations, and there's no replacing that. The future of our communities, the future of our people, our future existence is basically taken when our children are taking. And it's that annihilation of our families that is so threatening to us as Indigenous or Indian tribes and Indian communities, because the United States has made it clear within the Constitution and with the Supreme Court cases, laws, ordinance, and jurisdiction that only the United States has the ability to treat with tribes, and in order to establish and work with us to identify and acknowledge our rights as not only sovereigns, but our rights to maintain our communities as we see fit. And the attacks on our communities through our children is just so reprehensible that it also does provide us with the, I guess, the resiliency and the determination and tenacity to ensure that we fight for something that is so important to us as our children in our communities. The other aspect of stripping our children is also it takes them away from their families, their heritage, tradition, culture, community, and their sense of self, instilling the identities of our children and forcing into a better life as identified or as determined by an external force is clearly has had a detrimental effect. They've been stolen and fostered and adopted out, and parental rights exterminated and extinguished at exponentially higher rates than any other demographic. And the effects are still felt today for generations to come. When the Indian Child Welfare Act was enacted in 1978, it was to help to counterbalance some of the wrongs and some of the ills of failed Indian policy, as well as recognizing and protecting those communities and those families because our children had been taken away. Prior to ICWA, I still have cousins that we've never found. You know, I'm in that generation that was before the ICWA protection. So we've lost so many people to our communities. And at certain points they come back. However, a lot of times they don't even feel like they're worthy of being able to come back to community because they've been disengaged and torn away from the homes and community. So they don't feel part of something that is part of them. And yet there's that absence of that self and sense of self, just exacerbating the historic trauma that we all carry with us, basically stamped in our DNA today. And while there are a lot of families that are out there that have put themselves out there to be a home, whether it's foster or adopted, temporary or more permanent, that have a sincere desire to protect children, all children, including our Native children, to provide safe, healthy, and stable homes, other times our children were taken from us as novelties for some people to use as, look, I've got a great Indian kid and look at what we've done. Aren't we wonderful? And also with the passage of the Indian Gaming Regulatory Act, that went into a disturbingly bad trend of people taking our children as potential meal tickets and finding different and creative ways to take our children away because they thought that there was something advantageous to them or financial gain if they had one. So this decision and all the work that everybody put into it was just extraordinary and so exhilarating to us because there were so many components of the Indian Child Welfare Act that were under attack, but yet some of the fundamental principles seem to always get lost in the mix when we have these litigations, because again, you're only allowed to litigate on those points being brought up and sometimes not able to introduce or reintroduce fundamental principles of why we're even here today with these laws that protect tribes and tribal sovereignties in our communities. But I have to say that when the decision came down, Secretary Haaland happened to be in our house, literally in our great room, speaking with our tribal council on a visit. And so it was such a joyous occasion for us we cheered, we cried, we laughed. It was just, such a tremendous feeling. It still gives me goosebumps just thinking about it when it came down and how we were fortunate enough to have her in our community at the time. But that threat is still here. Just because we won that, cleared that hurdle, those threats are ever present and will probably remain. One of the things that, as you mentioned, when I was working as senior advisor to the assistant secretary on Indian Affairs, that was during the time where the new regulations were being promulgated and we are going through the consultation process. I'm not an attorney, nor do I play one on TV, so we just want to make sure that that's declared up front. But what I did do is I had the privilege and the honor of working with extraordinary team that were legal scholars and did work within that legal space of the solicitor's offices or the senior legal advisors to the assistant secretary to go over all of the comments. And we received thousands of comments, and each comment was addressed in detail. But what was really extraordinary was the efforts that they took to go through each one of the rules and regulations and the deliberative process there to determine how it can be attacked under litigation and what would be the likelihood of the rules prevailing under these attacks. So sometimes it'd be frustrating because not being a lawyer, I just want to see the end result. And as a chair, as the tribal leader and going through this in my own community and seeing the positive results, not only personally, but in my own community and in other communities, I'm like, well, can't we just say this? And they're like, no, we can't just say this. We got to make sure and run all the traps. So I got a tremendous education, but all I could say was such kudos to those people that worked on that because it held. And that's what was important. And that was the whole point of the frustrating deliberative process that they went through before those regulations went out, is because they knew that everything that's in there is always subject to litigation and hoping to prevail. But like I said, that threat is still with us, the reversal on that. And what we also have to recognize too is that there are children, Indian children, tribal children, that are beyond the reach of the protections of ICWA due to the eligibility and enrollment of each of the 574 federally recognized tribes. When you talk about blood quantum, those children might be all Native, they might be all Indian, but their parents were the last generation for eligibility of enrollment or their grandparents. So these children are beyond the reach of the protections. So we encourage all tribes to review that to make sure that your children that are the children of the community are still protected so that you increase or expand your eligibility for their enrollment so that they would be covered. And many of, excuse me, many of the things we want to do is look at the developing the familiarity community and culturally affiliated network for children so that there's placement opportunities and there's no delays in being able to get those children into a tribal home, a tribal facility, so that this way it doesn't engage so much of the states trying to do their job and provide them with safe homes and safe places. But we really do need to strengthen the tribal government's roles, assist, with these clinics and the work that you do. Assist in tribes writing strong intergovernmental ICWA agreements with the states, because that was the plan B. If we didn't have one, if it failed, then we had to drop back to plan B. And Minnesota has a really great governor that's worked with the tribes. I encourage any tribal nation to work with or try to get a copy of that and see if they can implement those types of provisions into an intergovernmental agreement, just to be an added layer, suspenders and belts per se, with regard to any upcoming attacks on the constitutionality or other confines of ICWA. And provide training to states to better understand their responsibilities under the ICWA, and then provide training for the tribes to better understand our rights and our roles underneath the ICWA. And using those provisions, and that's this decision to strengthen our sovereign status, favoring the elements of international custody and adoptions versus anything else, and going right back to the fundamental principles contained within the Constitution, where only the United States has the right to work in the plenary authority that we have, with that, and ensuring that when we're looking at any of these roles or any of these laws that are put in place for the protection of tribes, tribal sovereignty, tribal communities, it is as a way to undo all those failed Indian policies that have been in place for centuries already. We also, recommend staying vigilant in identifying other areas of vulnerability so that this way we're prepared for the next assault on the tribe's tribal rights, as well as, excuse me, working with legislators to increase and strengthen, the laws of ICWA. And then also, we're just happy to have a Supreme Court justice like Gorsuch that does understand and also trying to get into the head, which is always a dangerous place, of a Supreme Court justice that is so on the polar side as Thomas, that constantly looks of ways to eliminating tribes, tribal sovereignty, tribal governments, and the United States' responsibility to us, because we paid it forward with the lives of our ancestors, our lands, and our natural resources. We are the only constituency, the only political entities that the United States owes these fundamental obligations that don't go away just because it becomes inconvenient for the United States to uphold and honor these promises. So, we're looking at continuing to move forward, solidifying our positions, and I'm just so totally grateful for the work that you have done and will continue to do. And, as I said in the beginning, katapatash, katapatash, katapatanamo. Thank you to all of you for all your work and support. And please, as always, feel free to reach out if I can be of any help. Thank you.
Thank you so much, Chairwoman, for reminding us what's at stake here, and just for your beautiful, enlightening, and inspiring contribution. I know I personally was touched, and I saw many of our members nodding along with you as you were speaking, so thank you. Before we turn to our audience's questions, I want to open the stage for our other speakers. Would anyone like to comment on a statement of their colleagues or ask them a question before we move to Q&A? I think I'm right to take that as a no. Perfect. Feel free to interject at any point as I ask us some audience questions. So my first two I'm going to phrase together because I think they might complement each other well. And that is for anyone at all. How have tribal governments and state legislators responded to Brackeen and challenges to ICWA both before and after the decision? And what does ICWA support look like at the state level?
From our perspective, the Commonwealth of Massachusetts often, we go through peaks and valleys, and unfortunately, not having something like a really strong, solid intergovernmental agreement on roles and responsibilities really undermines the state's ability to memorialize it and keep the same consistency going. Rather than when we have changes in personnel. And that's something that we'd really like to work on. But we find that in many places, but there are so many good models of states that are doing it well that we really need to incorporate more of those principles into that and really encourage the tribes and the states to try to get to that level of having those intergovernmental agreements. Thank you.
And I would add as someone, so in 2013, Michigan passed the Michigan Indian Family Preservation Act, which was something that I was involved with at the time. And I would say that to the question of how have the state legislators and the tribal governments worked together sort of coming into Brackeen, we saw a huge increase in the number of state ICWA laws that were passed and adopted across the country. So I think we're up. The question of what is a state ICWA law is always one that I have a very strict interpretation. I'm like, it needs to be comprehensive. You can't just pass a law that says we will follow ICWA. I need some holes filled in the state law. So there's a number of them most recently. So Maine, Wyoming, Montana, the Dakotas, North Dakota, and Colorado, which passed one of those, will follow ICWA or we adopt ICWA. as state law, all passed sort of as we were coming into Brackeen. I was unconvinced entirely, although I think the chairwoman makes these really good points, right? That we needed state ICWA laws. I was like, we have a federal law. Why am I spending all this time on a state ICWA law in Michigan? And the things that I noticed, and another tribe was asking me about this just yesterday, advantages that I've seen are when it's in state law, it tends to be included in judicial education in a way that the federal ICWA was not for state judges, which I found really important. We ended up with more trainings on the law than we did when it was a federal law. And we had ultimately fewer appeals because we sort of narrowed some of the good cause exceptions, particularly the transfer provision, which Congress specifically articulates as a modified inconvenient forum analysis. And so in the Michigan law, we said it's an inconvenient forum analysis. If the forum is convenient, then you should transfer the case. And if it's not, it's not. And I think we had one Court of Appeals case on that and, haven't had an issue again. Our appeals have gone way down. So I've become kind of a convert to that. I would also say that there's a project ongoing right now that I'm the reporter for, that the Uniform Law Commission is considering whether to develop a uniform state ICWA law, particularly for states. And this is really clear because there's been a lot of discussion about the importance, which I do not disagree with, of tribal leaders in these processes and doing these state laws. I spend a lot of my practice in states that both don't have state ICWA laws and don't have tribal nations. So I am in Ohio, I am in Illinois, right now I'm in Tennessee, and it is rough out there. So if, the question of, is there enough motivation? Do we think that it would be useful to have a uniform state ICWA law that if there was momentum in a state that didn't say have tribal nations in it, but they still wanted to adopt for a reason, is that
Please enter the following verification code, 72855.
The information on the listening session is on Turtle Talk, and I truly am ambivalent about whether we should have a Model 1 or not. I don't know the right answer, and so I'm really curious to hear from tribes and what they think on it. So that's my plug. Sorry.
Thank you. Actually, while we're chatting with you, I do have a question for you. Can you expand more upon the shift that happens when a case moves from state to federal court? And are there certain states that are more likely to remove to federal court, and if so, why?
So you should not be removing to federal court in ICWA cases to start with. This is very frustrating to me. They're not supposed to be there. So no, actually, that's not true. There is a provision of ICWA that says if you violate sections 1911, 1912, or 1913, so the jurisdictional sections, the substantive protection of parents, or the voluntary provision of ICWA, under 1914, you have a right to collaterally challenge the decision in a court of competent jurisdiction. And the question of what is a court of competent jurisdiction really early was challenged by a lot of tribes. And so Craig Dorsey, who's been doing this for years and years, at the time represented Navajo Nation and tried to take cases into federal court as courts of competent jurisdiction to force the state courts to follow the law. And we were knocked down repeatedly. And that has happened repeatedly when tribes try to go to federal court. They, in the Van Hunnick case, right, out west, the Eighth Circuit struck down a series of victories under abstention issue. So what happens is it's not so much that the case, especially in Brackeen, that they were not removed, they were originally filed. So they were originally filed in the federal court. So Brackeen, and actually what went to standing, is they were filed as against the federal government, saying, federal government, you need to stop enforcing ICWA. And so they had different hooks to get into federal court, but they weren't the cases themselves, which made me wildly frustrated, especially when there was like ongoing Brackeen appellate litigation happening at the time they were also filing in federal court and no abstention discussion. So I don't mean to say there's no room for ICWA cases in federal court. I just mean in general, like that's not something that we do. And tribes have found very little relief when they've tried it.
Very interesting. Thank you so much.
Yeah.
I have another question from the audience. This seems to be to anyone generally, and that is, what measures have tribal governments taken in anticipation of further equal protection attacks on ICWA?
that's one of the primary things that we caucus about when we're together. Particularly, I'm sure we'll have a forum on it at National Congress of American Indians in November when we're down in New Orleans, because again, we know that this is just one skirmish that we fought off, and that these attacks are going to continue upon us. And that's why we were saying that by being able to have those backup types of agreements with this, and then looking at the vulnerabilities that we have in tribal federal Indian law. But one, I think part of what we're also trying to do is advocate that federal Indian law becomes a requirement in all law schools. There is no reason, with so much federal Indian law being brought through the courts systems in all circuits and all the way up to the Supreme Court of the United States, why there isn't a requirement for all students to at least have familiarity with federal Indian law and what those principles are there for. And, drilling right down into the Constitution and separating that we are not a race-based body of law. And once we start educating the people that are learning about it and doing the clerking for the judges, it makes the job that much easier for the attorneys that have to defend those rights and advocate for those rights in the court system itself.
Yeah, and the things that the chairwoman identified are certainly critical right now because, as Professor Berger outlined at the start, the court, of course, did not reject the equal protection challenge to ICWA. It merely said there was no standing, which was correct. But Justice Kavanaugh wrote a concurrence, which seemed to invite further litigation of that. And then there are challenges going on to other federal Indian law statutes like IGRA, where there are equal protection challenges pending in the court system right now. So this question of what are these racial classifications or political classifications is one that, and then what are the implications of that? That question and those questions are pending in the federal courts right now, and it's critically important that the kinds of things that the chairwoman outlined are happening and that advocates are prepared to deal with them.
Yeah, and I'm going to put Ian on the spot real quick, but I have taken small comfort in the fact that this court, and this is why I want Ian to correct me if I'm wrong, seems to find standing when they really want to find standing in cases. And Ian has a colleague that writes a really great Substack, which gets increasingly, I can feel like I can see him just typing angrily and angry over standing issues in federal courts. And I just felt I feel a little better about this issue in the ICWA context, and that I feel like there's lots of spots, exactly like what Ian said, in the non-ICWA context where this question is going to keep coming up. And so my pitch to the chairwoman in the Indian country is the education and the public relations around educating people on the distinction between the political relationship and citizenship and race is so critical. And I think especially when we're in our sort of federal Indian law or when we're in Indian country, it feels very obvious. Like it's something I'm always surprised at when I meet someone and they don't understand this. But I think that it is true that beyond Indian country, there's very, very little understanding of this concept. And to the extent that we start now doing that education, it will help the legal teams when it arises.
You remind me how lucky we are here to have access to federal Indian law classes, and definitely remind me of the importance of being educated on those fronts. The chairwoman brought up the Indian Gaming Rights Act. Can you expand on the interplay between that statute and litigation challenging ICWA?
Sure. It goes right back to not understanding that it's political and not racial, and that Congress had set the Indian Gaming Regulatory Act so that tribes would be able to, it'll level the playing field a little bit more so that tribes can gain a little bit of an advantage in order to have the jurisdiction and respecting the sovereignty that when it comes to Class 2, the tribes and the United States of America or National Indian Gaming Commission are the only people that have oversight on the operations of gaming, and you have all these other issues, thresholds that you have to meet. And then when it comes to like class 3, respecting the sovereignty that the tribe and the states negotiate in order to have a compact for that. And what we see is it's a constant assault on tribal sovereignty. So whether it's the Indian Gaming Regulatory Act, whereas tribes have got the sphere of jurisdiction and sovereignty, to the Indian Child Welfare Act, whereas the tribes have got this sphere of jurisdiction and authority over our children and the future of our communities. It all has to deal with the United States recognizing that tribes are sovereign nations, and we have the right and responsibility to make decisions based upon what is our unique perception on what is best for us, and giving us the opportunities to do that, to correct centuries of failed Indian law policies and Indian policies that have either tried to strip us of who we are or oppress and undermine the tribes as a whole. So it's across the board with any laws that have been passed that specifically treat tribes with respect, our sovereignty, and which uphold the trust and treaty obligations of the United States to tribes.
Thank you for expanding on that. Now, this question seems to be to anyone who wants to take it or comment on it. What evidence do any of you have that ICWA actually does service child interests? Given the concern ICWA, excuse me, my questions are moving as I'm reading, given the concern ICWA critics have that it is counter to child interests.
So this gives me a chance to get on my high horse about data, which is if we collected data properly about, frankly, all children in our foster care system, that would be really helpful. And I actually got repeated requests from reporters asking questions for data that we literally don't have on any child in the system, much less Native children. Where there is some and increasingly more social science articles out there on this. Most recently, one that I really like, Alicia Summers wrote one that had to do with what happens when tribes are present at the first hearing. And when tribes intervene early, we have better outcomes for kids. So one of the things she found was that, and by better outcomes for kids, we're talking about things like reunification with family or placement in kin relationships, right? So we're trying to avoid stranger foster care. We're trying to avoid termination of parental rights. We're trying to keep children with their families and their communities. This is something that ICWA legislated in 1978. This is something that we know are good for all kids at this point. So the question of what is actual evidence, the way the question's framed makes me wonder what evidence they're looking for, but also that it's hard to find actual evidence. And that evidence, when we're talking about funding, evidence of what works for kids in foster care is severely underfunded. And the numbers, when you're talking about Native kids, the statistical, the numbers that you need to create something that's what researchers consider statistically meaningful can be really difficult to achieve because we have children all over the country who are subject to ICWA, but are dispersed. And so the goal, I'll stop because the chairwoman has something to say. The goal is to have the federal government, the AFGARs, collect data, and I think they will start doing so, on children who are citizens whom ICWA applies to or eligible for membership, right? Because right now, all we have is a race category of Alaska, American Indian or Alaska Native, or Black or white or whatever. So I have children who are marked racially as Black, but are tribal citizens and receiving the protections of ICWA. I have Native children who are not tribal citizens who are marked as Native. They are not receiving the protections of ICWA because, as the chairwoman intimated, they're not classified for as ICWA. So that's a long answer. I'm gonna let the chairwoman go. I can do that for a long time.
Exactly. And, at the end of the day, in real time, we see it on their faces. When they're coming, when they're at powwow, when they're in community, at family tribal celebrations, and they're actually connected. I don't need a statistic to see what we see in real time on their faces. But as it has been mentioned earlier, and as is constantly mentioned, with the phrase, it takes a village, that is ultimately our way of life, and most Indigenous and most communities' way of life, that it does take a village to raise your children and to raise a community of caring and interactive individuals. But it seems like when we use the phrase, it takes a village, it seems to exclude tribes and tribal nations when it comes to protecting our children from people wanting to reach in and take them out. And we find that, even without the newer provisions since 1978 and all of the other information that is not really being captured properly, because as you know, excuse me, as Professor Attorney Fort had mentioned, that oftentimes our children are misidentified within the narrow explanations or narrow definitions. A lot of times it's the same thing. They look at somebody, they check a different box for them. And we said the best thing that they could start doing is the first question when anybody's going through intake is, are you a member of a federally recognized tribe, or is this child eligible for membership? At that point, the files take two different paths. If it goes one way, it follows the ICWA process. If it doesn't, it goes the other way. But there are too few states and or entities within a state that actually ask that fundamental question up first. But, answer to the question, the data is going to take a long time because they don't really want to capture it in most cases. But at the end of the day, when we see our children coming back home, whether they're coming home with their own family members or we have an agreement with somebody who may not be a tribal member, but they have been charged with the responsibility for caring for our children until reunification, we do have them sign an agreement that they will keep these children connected to the tribe and participatory in events to keep them as part of that. So thank you for that question.
Thank you. We're at time, but I can't think of a better note to end on than you could see it on their faces. And I so appreciate all of your time today. Thank you so much for joining us. Thank you for that wonderful discourse, so enlightening, and I know our students must be thoroughly enjoying this as much as I am. We're going to take a 5-minute break, and then we're going to go on to panel 2, which will be moderated by my partner, Julia Vasallo. Thank you so much. We're excited to continue soon.
Thank you.
Okay, now we're back, and on the second panel, we're fortunate enough to have a collection of esteemed professors and legal scholars of federal Indian law. And to start it off, we'll first hear from Professor Laura Briggs of the Women, Gender, and Sexuality Studies Department at UMass Amherst.
So I want to talk about how ICWA came into being. One of the ways courts and wider publics have misunderstood the Indian Child Welfare Act has to do with the fight about its history. Defenders of the idea of progress, that ways of thinking about the past in which we say things used to be bad, but now they're better, have seriously distorted the story of ICWA's passage as law is often told, even though the events are within living memory. It has become commonplace to say that ICWA was designed to remedy a problem during and right after the boarding school era, but now it's all better. Excuse me just a second, I've got to turn off. Consider, for example, the website SCOTUS blog's description of the Brackeen case. SCOTUS blog is a resource that sets out to be neutral in laying out the stakes in cases before the Supreme Court. It said, ICWA was enacted in response to a long and tragic history of separating Native American children from their families. This is a line that's been repeated almost verbatim in countless court decisions, briefs, and law review articles about ICWA, but it's based on a fundamental misconception about how U.S. institutions respond to injustice. It's based on a mid-20th century advocacy strategy that used social science and science to make doing the righteous thing seem natural and inevitable, but it obscures the activist history of who called for change and why, which allows advocates to engage in a seemingly dispassionate debate about statistics and history that we know has begun to fail repeatedly to serve Indigenous kids in court cases and in public debate. In this talk, I want to remind us that ICWA was born out of a struggle that began with grandmothers in North Dakota. In 1968, grandmothers of the Spirit Lake Dakota Nation with the help of a lawyer from the Association for American Indian Affairs, or AAIA, named Bert Hirsch, stood up to welfare workers who had taken children without any color of law and placed them in white homes. One of them, Elsa Graywind, stood in the doorway of her house and stopped a welfare worker from taking her grandchildren and putting them in a white foster home. She stood firm even when the police came and took her to jail. Elsa Graywind was, you could say, the Rosa Parks of Indigenous child welfare fights. Other Native households responded with other resistance strategies to efforts to take kids. They said later that they could see social workers coming because they drove fancy new cars, and so they hid children under beds in the woods or sent them fleeing with their parents through rural back roads. Despite the courage and toughness of women like these and the high value Native peoples placed on cultural survival, including especially through the rearing of children, tribal nations lost a lot of kids to welfare agents. Welfare workers disparaged the poverty of reservations and shamed mothers and others who cared for children. In part, they did so by refusing to acknowledge Indigenous kinship systems and the important roles of elders in child raising. For example, welfare workers took a kid named Ivan Brown and placed him with a white foster family because they refused to recognize the relationship of the woman who by Dakota tradition was his grandmother. And they said that at 63, she was too old to be babysitting for a child. Spirit Lake Tribal Chairman Louis Goodhouse made getting children back from the state a priority. The Spirit Lake Nation had taken welfare officials to court over and over again in the 1950s and 60s, insisting that they had no right to be on the reservation at all. Whether the children were being properly cared for was a matter for tribal leadership, they argued, and state welfare workers were just trespassers. Goodhouse even won a court order. Tribal members had gone all the way to the North Dakota Supreme Court to establish that tribal courts had jurisdiction over the nation's children, and they won their case in 1963. Still, welfare workers kept coming, insisting that as long as parents or grandparents were receiving state welfare money to care for children, they had a right to make sure the kids were all right, even if their definition of child protection meant rescuing them from their grandmothers. Louis Goodhouse turned to the AAIA for help. They sent Bertram Hirsch, a young lawyer, to get Ivan Brown back. Over the months of filing motions and trying to extract Ivan from the picture-perfect white foster family, Hirsch went house to house and found that a quarter of the children born to families on the reservation were either in white foster or adoptive homes or at an off-reservation boarding school. When he began collecting stories, Hirsch said, "Native people thought, this is my problem." They didn't know that a family a mile down the road or over the next butte was experiencing the same thing. Everybody feeling shame about it and not talking about it. They thought it was their own personal circumstances. So people kind of kept it to themselves and did not seek out assistance from their own tribes. Investigating further, he found that while Native people constituted less than 2% of North Dakota's population, their kids were 50% of the state's foster population. In 1968, a defiant Spirit Lake Tribal Council passed a resolution prohibiting county officials from removing children from the reservation under any circumstances. The court responded by halting all welfare payments to tribal households, despite a 90% unemployment rate. Grandmothers, the tribal chairman, and advocates from the AAIA traveled to Washington, D.C., and organized a press conference for the Foreign Press Club that caught the attention of President Lyndon Johnson and Secretary of the Interior Mo Udall, both of whom were very aware of the international condemnation of the racism in the United States. Johnson sent Udall to North Dakota to find out what was going on, and he urged state officials to back off and resume welfare payments. Over the next few years, other North Dakota groups, including the 3 affiliated tribes and 3 Lakota tribal nations, in South Dakota all joined the organized resistance to state foster care. The nations passed tribal council resolutions denouncing the manner and the rate at which children from their nations were being placed in off-reservation homes. Further, the AAIA began to organize across tribal nations and among advocates across Indian country, publishing stories about cases and the growing resistance in a newsletter they called Indian Family Defense. The efforts to interest Congress and pass a federal child welfare law related to Indigenous kids proved much more challenging. Repeated congressional hearings that centered the words of distraught mothers, grandmothers, and children produced no relief for Indigenous peoples and nations. At times, members of Congress seemed openly skeptical about their testimony. And you can hear it when one member asked Native leader and social worker Evelyn Blanchard from New Mexico how children could be taken from their homes and placed in boarding schools or foster care without a court order. Sometimes, she said, there's no authority. Some children are removed without any authority except the decision of the caseworker. That's what the association survey found, and it continues as a practice. What finally got Congress to agree to address the problem was still more research carried out by the AAIA, which spent more than a year writing letters and conducting interviews, ultimately compiling numbers from tribal nations across the United States and recording them on index cards. This painstaking effort produced the following statistics. 79% of all Native children of school age were forcibly sent to boarding schools from the 1870s to the 1930s. After World War II, state governments continued to remove Indigenous children, but now turned primarily to foster care and adoption in non-Indian families. By the 1970s, up to 35% of all Indigenous children were removed. These statistics, the kind of data that was particularly effective in legislation and court cases in the middle of the 20th century, was joined with testimony in Congress by experts, psychologists who talked about the harm to children and families, and sociologists and anthropologists who argued that Indigenous kinship structures were different from Anglo ones and were being misunderstood by welfare workers. In 1978, after hearing this time from mostly white men in favor of it, Congress finally passed ICWA after years of rejecting it. So the next time you read a decision or a law review article that begins by saying that ICWA was passed because of the high rate of Native children being taken from their families, I hope you'll pause and notice that the decades of court battles by the Spirit Lake Dakota Nation and the decade of intensive activism, lobbying, and congressional testimony are being glossed over. The grandmothers who were arrested, the cadre of volunteer lawyers who went to family courts to get Native children returned to their families, and even the surviving copies of Indian Family Defense that are available from any good research library but are rarely consulted. These stories matter to our current moment, not just as memory, but because the struggle for ICWA needs to be constantly renewed. For example, ICWA began to make a real difference for the first decade after it was passed. But in the late 1980s, there was a resurgence of demands that Native children could be rescued from their families as attention turned to terribly flawed claims about the prevalence of alcohol use among pregnant Indigenous people. Kids with Down syndrome and other developmental disabilities were diagnosed with fetal alcohol syndrome. Mothers went to prison, and a study from the 1990s found that once again, a third of Native kids in the United States were in out-of-home care. The forces arrayed against ICWA now are different. There are gaming lawyers representing non-Indian casinos and sports betting, and others who represent mining and other extractive industries that seek to undermine tribal sovereignty in the very old fight to take Indigenous land and resources. But whatever their goals, those who are seeking reproductive justice for tribal communities need a strong sense of the history of struggles that made ICWA into law. Thank you.
Thank you so much for that, Professor Biggs. One of our audience members left a comment expressing how thankful she was that you had time to mention and address in great detail Indian boarding schools and that history's connection to Brackeen, as well as the importance of grandparents as caregivers. Hopefully, when we get to the Q&A section, there might be some more on that. But for now, I think it's time to turn to our next panelist, which is going to be Professor Gerald Torres of the Yale School of the Environment and the Yale School of Law. Or law school, sorry. Okay.
Thank you. And Dr. Brute, I want to thank you for that history. The piece I want to pull out of it and highlight, because I think it's really critical, is the story of Indian agency. So it's not the story of victimhood. It's not the story of being objects. It's a story of agency at root. And that agency is what's really critical. So I want to take a slightly different tack, and I'll try to be brief, and maybe it'll spur some discussion. Rather than looking at Brackeen alone, I want to look at the analysis that Justice Coney Barrett used. I want to pull it apart a little bit, but then I want to put it in conversation with two other, I think, critical and important cases. One, I want to reach back a little bit and look at Justice Kavanaugh's justifications for for state jurisdiction in the Castro Huerta case, and then I want to also look at the treatment of the trust duty in the Arizona against Navajo case. And I want to suggest that there, as was suggested in the first panel, there's a lot of pieces in play, and the critical actors are Thomas and Gorsuch, and how they resolve some of these not yet really resolved questions, despite a 7-2 decision, I think are going to be important. Finally, I'll turn briefly, although it wasn't really decided, it was avoided, right? The question of the equal protection challenge, because when you start to count the votes in the equal protection challenge, it looks more like 4-4 with Coney Barrett in the middle rather than 7-2. And if that accounting is at all accurate, it means we're in for a continued struggle, especially around the topic that has a extremely vexed history in our legal and constitutional life, and that's the problem of race, right? And the way in which it even distorts this area of law where it ought not actually figure at all. So we'll talk. I hope I can do all that in the next 8 minutes. So we'll see. So if you think of this case as really a case about federal power, right? To what extent can the federal government do what it's tried to do in ICWA? The majority opinion and certainly Gorsuch's concurrence point to the validation of federal congressional authority to act in Indian country. Now, the problem, of course, is where you locate that power, right? And so in this era when the need to have a constitutional anchor for the exercise of the power, the question of the historic uses of the power in Indian country becomes a little more problematic. Okay, so that you have we'll start with the plenary power, which of course is wobbles in the face of Thomas's critique and even Gorsuch to a certain extent, right? So you have the plenary power, you have the Commerce Clause power, you have the treaty power, and then you have two additional sources of power that Justice Coney Barrett points to, right? One is the principles inherent in the constitutional structure, okay? which is important. Now, she qualifies that by using the word may, right? So the powers that are inherent in the constitutional structure may empower Congress to act, but she recognizes it as a potential source of congressional authority, even though it's not enumerated. It remains important. Finally, she turns to the trust duty, right? And she suggests that the trust relationship between the United States and Indian people informs the use of the constitutional power that Congress has. Doesn't justify it, informs it, right? So you have the constitutional provisions, and then you have these two other sources of power that are still not defined, right? What Justice Coney Barrett says, right, is that the power that the Congress exercises is plenary within its sphere. And then she says, but even a sizable sphere has borders. Okay, so we need to that suggests that the plenary power is bounded. Is it bounded by the enumerated powers? Is it bounded by the relationship between tribes and the federal government historically situated within the context of the structure of the Constitution? Is it bounded by the understanding of the trust duty and what that requires of Congress in its dealing with Native people? That, I think, is not answered. So I want to then shift gears a second and take us back to Castro Huerta, right? And I want to take us to Section 2, the beginning of Section 2 of that opinion, where Justice Kavanaugh says that the Constitution allows the states to exercise jurisdiction in Indian country because Indian country is part of a state and not separate to the state. Right? To be sure, under this court's precedents, federal law may preempt state jurisdiction in certain circumstances. But otherwise, as a matter of state sovereignty, a state has jurisdiction over its territory, including Indian country. Citation, 10th Amendment. Okay. So he constitutionalizes the exercise of state authority in Indian country, and then cites to the 10th Amendment. Of course, you need to compare that to Justice Gorsuch's concurrence in Brackeen, right? And what Justice Gorsuch does, and I think it's important, is to revivify the limitations that Worcester laid out. And what Justice Gorsuch tries to, it is only a concurrence, but what he does lay out, right, is the exclusion of state authority over Indians and Indian country, right? And so that's in direct conflict with Kavanaugh's construction of the Constitutional's permission for the states to exercise jurisdiction in Indian country. So that's one source of struggle we'll have to kind of fill out and define. And then you have Thomas's dissent, right, where Thomas says, the Constitution expressly denies certain powers to the states, such as the power to enter into treaties, but it is silent on the state's relationship to Indians. So his argument is there's no textual basis for the states to exercise jurisdiction in Indians country or over Indians. And so you have to look to only those places where state authority is expressly excluded. And then he cites to Worcester. But what his important citation to Worcester is to then point to Castro Huerta and say, Worcester was a formidable statement when it was issued. We now know it's been changed, and the most recent example of that limitation is in Castro Huerta. Okay, I have about 30 seconds to go and about 19 volumes to finish. So let's turn to the trust duty. The trust responsibility in Coney Barrett's opinion suggests that it's a basis for the federal government to exercise this particular kind of solicitude and power and authority to assist tribes in the satisfaction of their sovereign powers, right? But if you go back to Arizona against Navajo, what you find is, again, this very constricted notion of what the trust duty actually says. They both cite to Mitchell, but they take different implications for Mitchell. I'd be happy to answer questions since I'm almost out of time. Lastly, equal protection. It's out there. The equal protection challenge is, I think, still looms as a dark shadow on the regulation of tribal activity and individual Indians in particular. And my counting of the votes gives me some pause. And so I'll just stop there. So, thank you.
Okay, thank you so much, Professor Torres, for providing us with the framework to analyze Brackeen and other important cases in federal Indian law through your dissection of the power dynamics between federal, state, and tribal authority. And I'm sure we will get some questions on this area because, there are lots of very thorough points that I know you'd like to have discussed further, and I'm hoping you'll get the opportunity as soon as we finish this panel. But for now, I'll turn to Professor Gregory Yablowski, who is the Marion Rice Kirkwood Professor of Stanford Law.
Great. So thanks so much for the invitation to speak. Really, what a great pleasure to join such a distinguished panel of scholars and practitioners, people that we've been thinking about this case for a long time. I was actually thinking back, especially since we have a lot of students, about my own involvement in this case, which actually traces back in some ways to when I was a student, which was the case had not yet come about. But I would say my involvement began when I wrote a seminar paper as a law student. It was sort of like, oh, this question about Native peoples in the Constitution, I don't think has received adequate historical attention. Maybe I can dig something up on that. That was basically over a dozen years ago now. And that ended up being first one article and then another article. And then little did I realize, however, that sort of my historical research was then going to end up becoming germane to this very important constitutional challenge. So I think what this shows, if you are a student, is you cannot predict when and how the work that you do is going to matter in the long run. So I come at this as a historian, particularly interested in these questions of constitutional history that were raised by the litigation. One of the things about coming at it as a historian, I mean, I'm also a law professor and have legal training, but in these debates, it is frustrating as a historian to sort of encounter these discussions of, oh, you have such and such theory of how the Constitution should operate. As a historian, I don't necessarily embrace a particular approach or theory of constitutional interpretation. My view on my role in this case, and more generally, is to dig carefully through the history and try to uncover what people at the time of the adoption of the Constitution actually thought and believed about its meaning. I have an article in which I explore how I think that actually should include Indigenous peoples who had a lot to say about the Constitution, but for the purposes of the Brackeen litigation, this was mostly about what the white drafters of the Constitution believed they were doing and what the words of the Constitution meant. Now, this gets into this longstanding question at the core of federal Indian law about the source of federal authority in this area that is known as Indian affairs. And those of you who've taken the class, we've already heard a lot about the plenary power doctrine. I will say I think the term plenary power doctrine is a little confusing or misleading because it can encompass two sets of federal powers. One set of federal powers is the federalism questions that Gerald alluded to, and that is the question about the balance of power to negotiate with Native nations as between the federal government and the states. So we might think about this analogous to foreign affairs, right? There's a question about whether the states or the federal government have the authority to negotiate with, say, France or Canada. But no one argues that the federal government or states actually have some sort of jurisdiction or authority over Canada. It's a federalism question. And that was actually the primary question that existed at the time of the drafting of the Constitution. In other words, the issue that they argued about most frequently and most heatedly was the question of the balance of state-federal power in this area. Then there is this second meaning of plenary power that really develops much more, and I think is the more proper use of the term plenary power, that develops over the course of the late 19th century. And this is this idea that the federal government has the power to legislate for Native peoples directly over tribes, right? That this is the ability to enact criminal law for Native peoples, even on crimes between Indians. This is what gets upheld in Kagama. And then there's a series of precedents that uphold broad federal power to legislate for the tribes. And these two questions often get conflated. And I think one of the key things that I tried to do in my historical work on this is to try to tease these two questions apart. And I think the core question in Brackeen was really this first issue, the federalism issue, because ICWA is not a statute that attempts to legislate for over tribes. By and large, what it does is actually preserves a space in which tribes can set their own rules and norms for some of these questions and establishes jurisdictional boundaries. And instead is primarily about establishing the balance of power between states and the federal government. Okay, so I think that background is really important to understand the key questions at issue in the case. So we've heard a little bit about the multiple opinions about Gorsuch, about Thomas, and about the majority opinion. And I think all of them sort of tee up without fully satisfactorily resolving these the questions of the source of federal authority. Let me start with Thomas's concurrence. We've already heard a little bit from Ian about Thomas's distinctive take on federal Indian law, in which he wants to sort of uproot many of the foundational precedents. For better or for worse, much of my career has been spent trying to inhabit the mind of Justice Thomas and try to push back against some of the historical arguments that he makes. I think what's striking about Thomas is that he purports to be sort of simply neutrally presenting the history as it was, and he argues that that history argues for a much more cabined federal role and a much more expanded state role in federal Indian law. And so my hope is through my work, was to try to challenge some of the foundations of that. And I think one of the things that's frustrating about Thomas's opinion, and he does not seriously engage with contrary evidence, right? There is evidence from the founding era. It's not my evidence. It is evidence that I and Arston presented, in which they said, we do not think that the states will have much authority in this area at all going forward after ratification. And he mostly ignores or wishes that evidence away. It will be interesting to see how this plays out in the future. I think that's striking about Thomas's opinion is that he was alone. He got Alito to write a sort of different dissent, but the Thomas view that we should throw out all of federal Indian law does not seem to have gained any water, even with his fellow originalists. So my hope is that, at least by presenting this as a historical debate, we have blunted some of the effects of Thomas's views going forward. The majority opinion, I think, sort of stands for the idea that we're going to justify the existing precedent, which is very firmly on the side that there is broad federal authority in this area, as against states and as against tribes, although it doesn't delve into that. As Gerald alluded to, there's some hand-waving about what the exact source and nature of that authority is, suggests that there are limits without actually pointing to what those limits might be. It will be interesting to see whether that is an invitation to bring further challenges down the line. I will say I suspect that this at least will be the last word the court will say on this question for a little while, if only because I think ICWA is a much broader use of federal authority, particularly as against states, than many other congressional statutes in the realm of Indian affairs, most of which fall much more squarely into addressing questions about questions of Indian country, about jurisdictional boundaries close to reservation lands that even Texas conceded fell squarely within the heartland of federal authority. We'll see if I'm wrong about that, but I suspect at least that this is going to be the high watermark of this particular challenge, at least for a little while. Perhaps the court will revisit this question of what the exact boundaries and scope are, but I think the court did it only reluctantly because it had to in some ways. It's been almost 2 decades since it last addressed this question in Lara, and it could be another 2 decades before this question recurs to the court again. That leaves us with Justice Gorsuch's concurrence, which I think is very interesting, in part because he teases apart these two meanings of federal authority over Indian affairs and suggests what I think many federal Indian law scholars have argued for a long time, which is that there's lots of evidence to support a broad federal authority as against the states, but much less evidence to support expansive federal authority as against tribes. This, I think, is the view that many people in federal Indian law have long advanced. However, that part of the opinion also, he only gets one person to sign on, or he's by himself, right? The two liberals who join the rest of his opinion do not join that part of Gorsuch's concurrence. So I think this is a powerful statement, re-envisioning of federal authority. I think it has a much firmer grounding in the historical evidence, but we'll see how much support that goes going forward. I think for now, the court feels most comfortable doing what it has always wanted to do, which is sort of rest on the existing precedent and sort of wave the issue away, at least for the time being. We'll see if that's what plays out. Let me say a couple words about what I think the future holds or what I think the next step should be. So personally, I mean, as those of you in the field know, this question of federal authority or plenary power in federal Indian law has long been one of these hotly contested chestnuts that the field has argued about for a long time. Personally, I would like to see us spend less time debating federal plenary power, at least in this sort of broad, abstract sense. In some ways, I feel like this attention has been focused on relitigating some of the abuses of federal authority that happened in the late 19th and early 20th century. I think there's no question that, we already talked at some length about the boarding school era. This, I think, was part of a broader era of really egregious use of federal authority to try to commit cultural and sometimes actual genocide against indigenous communities. I think the view is that if there had been a more robust set of constitutional checks on federal authority during this time period, then those abuses might have been avoided. I think there's a lot to the, I think the abuses are extremely clear. I think it's a little misleading as a matter of constitutional law to sort of try to frame our constitutional theories to address to try to refight the fights of the late 19th and early 20th centuries. I think the challenges the Native peoples face now are distinct and present a very different set of challenges, which are not necessarily about going to stem from Congress, although I think obviously there's always still some danger that Congress is going to enact some harmful legislation. But I think the court itself has become a much more dangerous source of doctrine for Native peoples in the present. And I think some of the more harmful effects of federal law in recent years that actually come out of the Supreme Court. This is, of course, not something new. Federal Indian law scholars have been pointing this out for quite a long time. And so, as Gerald already alluded to, I think one of the greater dangers right now is not that the court will embrace a sort of untrammeled view of federal authority that will then be unleashed against native sovereignty. I think the greater danger is that Thomas's views will gain ascendance, not as a constitutional matter, but more as a statutory and administrative matter. In other words, the cabin division of federal authority will then be used to justify an expanded and resurgent state authority in Indian country. And of course, we already saw that in Castro Huerta in precisely the section that Gerald alluded to, where Kavanaugh's view, where he cites the 10th Amendment, is, I think Justice Gorsuch calls it as misguided a statement as can be found in the history of federal Indian law, or words to that effect. I think that's very clear. If you purport to be an originalist, then I think it's very clear that the historical evidence is against that position. But I do think that that is going to be one of the more significant fights going forward, right? I think that this question about what the role of what the balance of power is in federal Indian law and what role the federal government has in affirming native sovereignty and protecting against the scope of state jurisdiction is going to be significant. I think it's striking, right, as Gerald alluded to, that Thomas wants to disregard a decision from the early republic in favor of a much more, a decision the court reached last term, despite the fact that, one of those purported originalists was decided much more closely to the founding era. So I think that is the fight. I think, these questions about plenary power remain important. As an academic, I'm intellectually extremely interested in them. But I worry that the battle that we should be gearing up for and that Native nations are going to be facing after Brackeen is actually the fight of Castro Huerta, right? It's going to be the fight of aggressive states using some of the broad deregulatory, anti-regulatory doctrines that Seth is really expert in and might be talking about momentarily, to try to attack some of the principles of federal power in order to establish a robust state jurisdiction in Indian country. So that's what I'm gearing up for and thinking about. But I'm really pleased that for now, at least, we seem to have resolved the immediate challenge to the Indian Child Welfare Act.
Thank you so much for that, Professor Oblowski, for providing us specifically with a historical perspective on the ways in which interpretations of the U.S. Constitution have impacted federal Indian law over time, and for your discussion of federal and tribal nations in the context of federalism and foreign affairs, which I, for one, found extremely helpful. And I think it's time to turn to our last professor on this panel, Professor Seth Davis of the University of California, Berkeley Law School.
Thank you. I really appreciate the invitation to be with you via Zoom today, and also the opportunity to close out this panel. I have learned a lot from the work of all the scholars on the panel, and so it's a real honor to be here. I really appreciated Professor Briggs's opening this panel with a story that emphasized Indian agency in the story of ICWA and its enactment. Of course, Indian agency, in part, in that story is directed towards federal power and the federal government. And both Professor Torres and Professor Oblowski talked about the question of federal power. My remarks, to an extent, will bridge between their two sets of remarks. And Professor Oblowski is right that one of the things I will emphasize in my remarks is the question of state power and state challenges to federal power. So what I'm going to do is talk about the structural constitutional attack on ICWA and the ways in which it aimed not only at longstanding principles of federal Indian law, but also at longstanding principles of administrative law and constitutional law. So again, to take up Professor Torres's framing earlier that the case Brackeen is about federal power, I'd say it's no secret that a majority of the current court is skeptical of federal power, but it's also not a secret that their skepticism is inconsistent. Federal power for certain ends, think for instance of the power to exclude non-citizens, isn't greeted with the same skepticism as federal power for other ends. Think, for instance, federal power to combat climate change. To pick up on another Professor Torres's point, there's a story to be told about race and administrative law there as well. That's not the story I'm going to tell today, but it's an important story to tell. For me, Brackeen brings home a lesson that federal Indian law cases today are rarely just federal Indian law cases. We've long thought about federal Indian law as exceptional, but what strikes me about several of the structural attacks on ICWA is how familiar they seem if you've been following a whole variety of state cases brought in federal courts against federal power. and those state arguments seeking to hobble the federal government's authority to regulate and to protect rights. So there's 4 structural issues in Brackeen that I'll highlight today. And I should say that there were very bold and less bold versions of the structural arguments against ICWA. And the boldest versions underscore that the attack on ICWA threatened not only federal statutory protections for Indian children, but also federal supremacy and federal administrative power generally. The fact that the Roberts Court, or should I say the Kavanaugh Court, rejected these arguments might comfort those who are worried about the court's trajectory in these sorts of cases, that is, constitutional administrative law cases. So maybe it's comforting. Or maybe it confirms my sense that various litigants, particularly Texas and its allied states, were trying to shoehorn their structural constitutional hobby horses into the Brackeen case. Now, I know I'm mixing metaphors with that sentence, and it's deliberate. The briefing from the states and various amici was a mishmash that only made sense to me anyway, when I recognized that many of the arguments weren't really about ICWA or how it actually operates in the world. They were about shifting the Overton window on federal power in the federal administrative state. For me, one of the touch points with other forms of public law litigation is the way in which Brackeen became another example of ideologically charged state litigation against the federal government. And I've written about this both with Republican attorneys general and solicitors general bringing these cases, and Democratic attorneys general and solicitors general bringing these cases. Although, and we can talk about in the Q&A, I don't think that there's sort of parity between those two in terms of how far they're trying to shift the Overton window. I should also disclose that I filed an amicus brief in this case in support of Secretary Haaland and the tribal parties. And my remarks today in part reflect some points in those briefs. Okay, so let's talk about these structural principles that I want to highlight to try to add to the discussion we've already had. So we've already talked about whether Congress had authority to enact ICWA. Obviously, the first structural principle at issue was that Congress has the constitutional authority to enact laws concerning Indian affairs and laws that fulfill the U.S.'s unique responsibility to Native peoples. My fellow presenters have discussed Congress's authority to enact ICWA. I'm not going to rehearse everything they've said. There's a few things that I'll highlight. First, I thought it was interesting when we're talking, as Professor Torres invites us to do, about the use of the word spheres in talking about federal power versus state power. I mean, one of the things that was interesting to me about Justice Barrett's sort of shifting use of that word is that there's a big chunk of the opinion that I read as implicitly resisting the shop-worn notion that our federal system is one of clearly delineated, mutually exclusive spheres of sovereignty, in which federal authority is exclusive within one sphere and state authority is exclusive within the other sphere. Of course, as an account of how government actually works in this country, that's nonsense. It's just nonsense. But we hear a lot about dual sovereignty and separate spheres. We heard about it in Alito's dissent. There were even some similar uses in Barrett's own opinion. But I think overall, the court implicitly acknowledged that we don't have these clearly delineated separate spheres. Second, the court rejects a narrow reading of the word commerce in the Indian Commerce Clause. Hats off to Professor Oblosky for doing so much amazing work on the meaning of that word in that clause. I'm not going to reiterate what he said, but I'll just stress that the court doesn't limit it to trade, and that's important. And then third, and the court rejects the petitioner's approach, its methodology for looking at the constitutional question here. As the court puts it, the petitioners, quote, frame their arguments as if the slate were clean, end quote, which apparently was a mistake because there had been hundreds of years of legislation, executive action, and judicial decisions that Justice Barrett and those that joined her opinion wanted to reckon with. All right. So next question. Does ICWA violate the anti-commandeering doctrine? the first thing I ever wrote as a legal scholar, not even a legal scholar, as a student, was on the anti-commandeering doctrine. So it was interesting to see it arise in this case, in part because, wow, it really wasn't all that relevant to this case, as we found out. But okay, the second structural principle at issue was that Congress has the authority to enact supreme federal law that state judges must apply when adjudicating state law causes of action. So ICWA challenges this principle by pointing to the anti-commandeering doctrine, which is something that the Rehnquist court created and which the court has reaffirmed. But the court told us in Brackeen, no anti-commandeering problem. So Westlaw tells us that there's actually 5 anti-commandeering holdings in Brackeen. The court tells us there's 3 categories of anti-commandeering issues. I don't know, 5, 3, whatever. The 3 categories the court identified were as follows. 1, ICWA's requirements for involuntary proceedings did not violate the anti-commandeering doctrine. 2, ICWA's placement preferences did not violate the anti-commandeering doctrine. And 3, you know where I'm going, ICWA's record-keeping requirements did not violate the anti-commandeering doctrine. So what is the anti-commandeering doctrine? Well, it's a principle the court has said is implicit in the 10th Amendment and the structure of the Constitution. And the principle entails a few rules. One rule is that Congress may not command state legislatures to enact specific legislation. Another rule is that Congress may not command state legislatures to refrain from enacting specific legislation. And a third rule is that state executives are not bound by federal commands that they administer federal regulatory programs. Now, notice that I didn't say anything there about state judges. That's because the court has never held that the anti-commandeering doctrine exempts state court judges from their obligation under the Supremacy Clause to apply federal laws when they apply. The Supremacy Clause says that state judges are obliged to apply the supreme law of the land, that is, federal law. And the boldest anti-commandeering arguments against ICWA attack the Supremacy Clause. The argument, which focused on ICWA's placement preferences, was that the Supremacy Clause does not require state court judges to apply federal law when considering a state law cause of action. So that would be a state law cause of action exception to the Supremacy Clause. But there's no such exception. End of story is what Justice Barrett said about that. So a third structural principle I'll highlight is that Congress has the authority to regulate state actors through even-handed laws that confer rights and impose the same responsibilities on state actors and private parties alike. ICWA's challengers sort of tried to attack this principle and then sort of tried to, or really tried to say that the precedents establishing that principle weren't applicable. Why? So Texas tried to draw a line between commercial and sovereign activities of governments. Now, this is actually a familiar line. We see it in other areas of law. And the court said that the relevant provisions of ICWA didn't fall under these precedents because those precedents all involve states acting as market participants. If you want, in the Q&A, we can talk about state DMVs. It's one of the key precedents coming out of state DMVs and congressional regulation of them and private parties. But anyway, Texas said ICWA's regulating us in core sovereign functions. Now notice, the court doesn't actually reject the idea that there's such a line between these two things, or these two capacities. Justice Barrett says the petitioners hadn't given, quote unquote, details to show that ICWA commandeered a core sovereign function. And then finally, the court said that since 1790, Congress has required certain ancillary record-keeping requirements they've imposed them upon states in relation to state court proceedings. So ICWA's record-keeping requirements were just fine under that history. So their history mattered in that way. I'll conclude by saying a few words about the non-delegation doctrine. So the fourth structural principle that I'll highlight is that the non-delegation doctrine doesn't prohibit Congress from incorporating another sovereign's policy judgments into a federal regulatory scheme. There were two non-delegation issues in the case. One was, has Congress set forward an intelligible principle in ICWA? The non-delegation doctrine requires Congress to set forth an intelligible principle when delegating policymaking authority to administrative agency. That's not a demanding requirement. U.S. history is full of statutes that authorize executive action with little in the way of direction, but during the New Deal, the court invoked non-delegation to invalidate a few pieces of New Deal legislation, and ever since we've been waiting with bated breath for another statute to fall on non-delegation grounds. We're still waiting after Brackeen. The other non-delegation issue was an attack on tribal sovereignty because Texas and one of its amici argued that Section 1915 of ICWA violated the private non-delegation doctrine, which the court had applied, or at least a plurality of the court applied in Carter versus Carter-Cole. In that case, the court's plurality found issue with a statute that authorized an industry cartel to make binding rules concerning labor for the industry. So what does Carter-Cole have to do with ICWA? Nothing, really. But Texas argued that Native nations should be treated as private parties for purposes of the private non-delegation doctrine. Court rejects that argument. There's some prior precedent, Masery, that the court could point to in rejecting that argument. I'll just note, if the court had accepted Texas's argument, it would have radically undermined a variety of cooperative regulatory schemes that include both tribes and states in their implementation. But the court said no standing. Great, no standing to reach the equal protection challenge, which, as my fellow panelists have pointed out, will persist into the future. I think, Professor Torres, you said it might be a shadow or something to that effect to be aware of. I think the non-delegation argument is over for a variety of reasons I'm happy to talk about. But I'll conclude by saying, let's not ignore the sorts of intersections between administrative law and federal Indian law. The court's been making major changes to administrative law, including in its newly strengthened and expanded major questions doctrine. Over the past few decades, there's actually been a few federal Indian law cases where some litigant has challenged federal agency action by invoking the major questions idea. And now we have the court embracing a particularly robust version of that idea and suggesting that agencies need clear authorization to make policy concerning major questions. And we see lower courts grappling with that in various cases. So to sum up, ICWA is still standing, but the equal protection remains. The administrative state is, well, here for now, and we'll see.
Thank you so much, Professor Davis. I really appreciated your detailed analysis of the structures at play in ICWA litigation, as well as state power in the context of federal Indian law and the widespread skepticism of federal power. I would now like to invite our panelists to respond to one another before turning to questions from the audience, if anyone would like to jump in.
Well, I just want to thank Professor Davis for putting this case in the context of that wider struggle over federal authority, because I mean, you could say we're in a golden age of administrative law from an academic's perspective, right? From somebody who actually has to make government work, maybe not so much, right? But I think it's really important. I think the points you made are incredibly important for understanding how this case fits in that constellation.
I'm actually curious, Professor Davis, let me piggyback. What do you make of the fact that one of the primary proponents of this sort of deregulatory move is Justice Gorsuch, right? I mean, in other words, what do you do with the fact that at some point, perhaps, there's going to be a collision between Justice Gorsuch's views on federal Indian law and his views on the major questions doctrine and these other sort of deregulatory administrative doctrines?
Please enter the following verification code, 30612.
Is Chevron and the question of judicial review of agency statutory interpretations. There can be a conflict in a particular case between the Chevron doctrine and the Indian canon of construction when we were dealing with an ambiguous statute. And one could very well imagine tribal litigants saying, we need Gorsuch's vote in this case. And one way to do it, to get it in this statutory interpretation case, is to emphasize the Indian canon, emphasize the history he's so interested in, and argue against Chevron, right? Certainly, one could imagine a case that sets up that very issue. I think such a case would be complicated even from a tribal litigant perspective. when we think about often for ill, but the outsized role that various federal agencies, not just the BIA, can play in the exertions of federal power that affect Indian peoples. And there could be cases where one would want to rely upon Chevron in defending a federal executive action, either clearly within the federal Indian law space or in some space that affects Indian peoples. So I think that's a really hard question. I think the answer for the litigants is often going to be some difficult combination of the contingencies of the particular case and how much you're trying to take the long-term view. I think for those of us who are scholars, to harken back to Professor Torres's point, it does raise some really rich areas for discussion. There's much more I could say about that, Professor Oblosky, but perhaps I'll tamp down my enthusiasm and just let that stand as one concrete example of where the question is quite difficult.
To your point, if I could just add this one piece, then we can turn to the audience, I guess. But Thomas's challenge to the continued vitality of the Indian canons of construction, right, in Arizona, is like, you got makes you take a deep breath.
Okay, this is kind of on a similar note, so I'm just going to ask this question, which came from our audience, and the question is, how do you all think the other justices in the Brackeen majority will side on the Gorsuch-Kavanaugh divide on the 10th Amendment and jurisdictional divides in future Indian law cases?
Griggs, this is yours.
Sure. I mean, unfortunately, we already have the answer to that, right? I mean, we have Castro Huerta, and we saw how they sided. I mean, 5 of them joined with Justice Kavanaugh. Barrett was the key vote there, right? I mean, I think Barrett is, for better or worse, and I fear a little bit for worse, now this swing justice in federal Indian law. Because I think what we have is a 4-4 court where we have the 3 liberals plus Gorsuch are usually pretty reliable pro-tribal votes. We have 4 pretty skeptical conservative justices on the other side. And I think Justice Barrett is going to be a swing vote. So I was really disheartened by her vote in Castro Huerta, and I worry what that augurs for the future. I mean, I think I was cautiously optimistic after Isleta, where she was actually joined with those other 4 justices that I mentioned a moment ago to issue a pro-tribal decision. The fact that she authored the decision in Brackeen was somewhat encouraging, and there were a lot of positive notes in there. But I worry that, at least on this question of state sovereignty, she's going to continue to side with the states.
Although I guess there's a question of whether she'll side with the states when tribal sovereignty is invoked, really the reservation is a shield, right, for Native people themselves, right? And I find it hard in general to actually predict. I find the prediction business when it comes to the court to be oversold often. But, I don't know that it's clear, Professor Oblosky, if she might maintain that sort of line.
Yeah, I think we'll get a test of that. I mean, I think we will. I think the one thing that's clear is that Castro Huerta was not the last time this is going to be litigated. Already there are cases bubbling up, involving extending the principles in Castro Huerta to non-member Indians and other categories. So I think that we'll see. I agree with you. Predictions are not worth much. But I at least was more. I'm already suffering a little bit of disappointment because I was slightly more optimistic after the Castro Huerta oral argument. So I've reverted to my natural pessimism.
Okay, if we're ready to move on to the next question, this one came in specifically for Professor Torres, so I will start by addressing you. But if anyone else wants to jump in, you're welcome to. The question is, why isn't it clear that Justice Barrett would be hostile to any affirmative action and thus sympathetic to the equal protection claim?
That's a good question. I think probably because contrary to Greg, I'm kind of stupidly optimistic that hope can be found. But yeah, no, I mean, I think she, you know, one of the questions will be how, what's the form in which the question arises to the court, and whether there'll be a way for them to situate this kind of, you know, squarely within kind of tribal or Indian jurisprudence. You know, or whether it bleeds over into a place where you know they find that their race jurisprudence takes precedence, and if it's a place where their race jurisprudence takes precedence, you know, it'll be a drag. I mean, I could maybe phrase that a little bit better, but one of the things that you should look at, I think, are the insular cases, and how the issue arises in those cases, and then, you know, see what you can you know, squeeze out of that, I guess. So yeah, so I'll pretend to be optimistic.
Okay, I'll move on to the next question, which is, do you see the anti-commandeering and equal protection challenges to ICWA returning to the Supreme Court in the near term?
No on anti-commandeering. I think that we got some pretty clear statements from a strong majority of the court on that. Equal protection, I think it's there, right? And obviously, I'm not litigating these cases, the ICWA cases, right? And so I know that we've heard from other presenters today who are in a much better position, given their expertise, to prognosticate about how quickly and in what form it'll come up. But I think, at least on this panel, several of us have said the equal protection challenge is one to continue to watch.
I'll contradict my earlier statement and say I'm slightly optimistic on the equal protection challenge, precisely for the reasons that I think Kate alluded to in the last panel, which is this court, when it wants to take up an issue, it can do so, right? If it wanted to find standing and grapple with the equal protection question, it could have. I think it was noteworthy that only Kavanaugh, among, you know, neither Roberts nor Barrett wrote anything on the equal protection question. So if you're counting noses, you know, that suggests you have to get at least one more justice to sign on before it's plausible before this court. So what I read this as is a court that didn't want to grapple with that question, and so punted it. And so if they don't want to take up this question again, they are very powerful ways to avoid doing so for a while. Now, what that doesn't resolve, however, is that it might be a mess in the lower courts for quite some time, right? So I think that is perhaps the greater danger, is that, you know, courts might be all over the place on these equal protection challenges, reading the tea leaves in Brackeen, and you'll get, you know, right-wing judges citing Kavanaugh's concurrence as if it were, in fact, a majority holding.
That was going to be my point. I mean, the problem is you have that Kavanaugh concurrence kind of like blinking like a flashing light, and, you know, does it offer a roadmap? Well, I don't know, but it's certainly, if you wanted to litigate that in the lower courts, I think you're right. But I do agree with you that there wasn't much appetite to take it up in this time, but we'll see.
Okay, we have one more question that we have some time for before we're going to wrap it up with some closing remarks. So the last question that I'll pose is, do you think Justice Gorsuch's efforts to build out an originalist history and jurisprudence of tribal sovereignty between his Brackeen concurrence and his Navajo Nation descent will be effective in future Indian law cases?
Well, I guess I'll take this as the originalist whisperer. I think it's a question of what we mean by effective. Right? Do I think that it's going to produce a wholesale rewriting of federal Indian law. No, I don't think so. I mean, the fact that he was into the dissent in Navajo Nation and the fact that he was basically writing for himself for large sections of that originalist theory in Brackeen suggests that. But I think it could exercise a gravitational pull in the same way that Thomas's writings on this question can exert some influence, even if they don't become the majority question. I mean, they produce, I think you get some academic discussion, you get discussion on originalist blogs and places that originalist jurists pay attention to and read. You get a sort of robust debate. I think the fact that Gorsuch fits very squarely within this sort of movement conservative vein, but is constructing a sort of pro-tribal position, helps blunt actually the effect of Thomas's views. In fact, one of the things I anticipated when I wrote my brief was I was like, okay, I need to give ammunition to Justice Gorsuch so he can use it against Justice Thomas precisely in this sort of originalist contest. So I think that is the most likely outcome, is that there will be an ongoing debate sort of that happens in concurrences and dissents about what the right position will be. I suspect for the majority in the future, they will continue to come out the way that they do here, which is that they say, well, we have these precedents that uphold broad federal authority in this area, and so we don't necessarily need to revisit the question. But I think it creates a space for academics, for movement lawyers, for other people to pay attention to this area who haven't necessarily done so before, and to do so in ways that, Justice Thomas is not the only conservative voice here or the only originalist voice, that maybe gives some support and protection for Native litigants.
Okay, with that, I will now take a moment to welcome Casey Corvino back up to join me in closing remarks. Okay, so I will start by saying thank you for attending our symposium, Interrogating Haaland v. Brackeen, Family Regulation, Constitutional Power, and Tribal Resilience. We hope our symposium has fostered an open, accepting, and intellectually stimulating environment. Casey and I would also like to take a moment to extend our gratitude to those who made this event possible. Thank you to our speakers for their time, knowledge, and willingness to engage with the far-reaching impacts of Brackeen and larger challenges to tribal sovereignty and Native families. Thank you to Professor Bethany Berger for her invaluable guidance and support, and for sharing with us her passion and expertise in this area of the law. And we appreciate the tireless efforts of our fearless leader, Gretchen, who is the editor-in-chief of the Connecticut Law Review, in helping to bring this event to fruition.
Thank you. Thank you to the Connecticut Law Review Symposium and Communications Committees for graciously dedicating your time and energy in the lead up to the symposium. Thank you to the Connecticut Law Review membership for your support of the symposium on such an important and engaging area of the law. Thank you to the UConn Law Administration and staff, particularly Dean Ebony Nelson, Quentin Brooks of the IT department, and Events Manager Deb King. Without all your insight and assistance, this event would not have been possible. And lastly, thank you to every attendee who has decided to engage with us and learn more about the context, impact, and importance of Haaland versus Brackeen. As Chairwoman Andrews Maltese said, it takes a village, and we are hopeful that discussions like these will create a new great village that centers the tribes and indigenous peoples most affected by ICWA, which dedicates itself to ensuring children have strong ties to their history and peoples. Thank you.